Generally speaking, a police officer, like any citizen, has an implied license to approach a home, knock on the front door, and try to engage with the occupants in a consensual conversation. This is known as a knock and talk exception to the warrant requirement under the Fourth Amendment. Whenever I post about this exception on YouTube, somebody always comments and says that they have "do not trespassing" signs all around their house. So the question becomes, do they work? Well, today we're going to look at the case from the 10th Circuit where an individual posted a bunch of signs all around his house and the front door that say "do not trespass" or be prosecuted. Can the police officers still approach the door and knock, or are they violating this individual's Fourth Amendment rights? Well, we'll find out today. If you're new to the channel, welcome to the Law Stash channel. Every Wednesday, I discuss and we go into a deep dive on one case. Today's Wednesday, we're going to be discussing this particular case that deals with a knock and talk exception and the "do not trespass" signs. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. If you're new to the channel here on YouTube, hit that subscribe button now. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the "Do Not Arrest This Person" t-shirts, stickers, and some other items. And one last thing, if you have a criminal case anywhere in California or Nevada, this is exactly what I do. So go ahead, give me a call, and I'll be happy to discuss your particular case with you. Thanks for watching. Let's go on.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Carlos, which is a 10th Circuit case, and it deals with the knock and talk exception and the "do not trespass" signs. First, let me give you some factual background. ATF agents received a tip that Mr. Carlos, who was previously convicted and was a felon, was in possession of a firearm, probably a machine gun. Two ATF agents made a decision to visit Mr. Carlos at his house and try to engage with him, ask him questions about the firearms, and probably the motive was later to search the home. When they arrived to the property, there was a house, there were no fencing or any sort of barriers between them and the front door. However, there were a bunch of "do not trespass" signs all around the property. There was a sign on the post near the driveway. There was another sign on a tree attached to it on the side yard. And there was even a sign on the front door. The front door particularly said, "Posted private property. Hunting, fishing, trapping, or trespassing for any purpose is strictly forbidden. Violators will be prosecuted." Now, all of these signs were professionally printed. They were yellow with black lettering. They were nicely made. Nevertheless, the officers approached the front door. They knocked for several minutes. And after a while, Heather Wilson exited the back door of the house and met with the officers on the side yard. Now, the officers told Miss Wilson why they were there, that they were really interested in talking to Mr. Carlos. A few minutes later, Mr. Carlos also exited the back door and met with the officers. Again, the officers explained to Mr. Carlos why they were there. They asked him about the firearms. Of course, he didn't answer any questions about that. Later, they asked him whether it would be okay for them to look around the house. Now, he said that he did not own this home and he needed to speak to the man of the house to see whether that person would allow them to search it. Now, he then wanted to go into the house and talk to the owner. This is where the story is a little bit different. Mr. Carlos says that when he was going to go into the house, the officers told him that they had to go with him. They would not allow him to leave. Now, the officers testified that the story was slightly different. They said that they asked Mr. Carlos whether it would be okay for them to accompany him into the house. And he said, sure. So the stories are slightly different. But here's what happens next. The officers, together with Mr. Carlos, go into the house. There, in plain view, they see methamphetamine paraphernalia and some white residue in Mr. Carlos's room. When they get to the owner of the house, he tells them that he does not consent to searches and does not allow them to search the house. Now, they already have some information. They have this residue. They saw paraphernalia. So the officers obtain a search warrant for the house based on that information. The search of the home, the extensive one pursuant to a warrant, yielded a bunch of firearms, drugs, drug paraphernalia, and some other items. Mr. Carlos was charged with drug possession and firearm possession because, again, he was a felon, previously convicted of a felony. He tried to suppress all the evidence found, saying that the officers violated his Fourth Amendment rights when they knocked on the front door. He says that he had the do not trespass signs attached all around the property and on the front door. And if there was any implied license for any citizens to approach the front door, he says that that license was revoked when he put the signs up. So the question, of course, becomes whether the officers are permitted to walk up to the front door, knock on it, despite these signs. Now remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Now, your home is explicitly protected under the Fourth Amendment. It is mentioned in the Fourth Amendment if you read the text. The area around your home, called curtilage, is also protected under the Fourth Amendment. This is the area that's intimately surrounding your home. And usually, under the Fourth Amendment, the court said that area becomes part of the home. So here, of course, we have signs all around the property and on the front door. So let's talk about the knock and talk exception. Here's the definition of the knock and talk. Specifically addressing an investigative knock and talk during which police officers knock on the door of a home seeking to speak with the occupants, this court has held a commonly understood a knock and talk is a consensual encounter and therefore does not contravene the Fourth Amendment, even absent reasonable suspicion. The home's occupant, however, remains free to terminate the conversation or even to avoid it altogether by not opening the door. Now that you understand what is curtilage and the knock and talk exception, let's talk about the no trespassing signs. At the outset, the court says that these signs do not create some special privacy zones. The sign alone does not give you any sort of special protection. Now, let's talk about these signs that Mr. Carlos had. He had the no trespassing signs all over the front yard and the side yard of his property. The court says that the Fourth Amendment protects your home and the curtilage around your home. It is Mr. Carlos's burden to prove that that area was part of the curtilage. Now, the court says that they believe that the area was actually part of quote-unquote open field. And the Fourth Amendment does not protect you in the open field. They said because the property did not have any fence around it, the front yard and the side yard were not intimately connected to the home. So for those reasons, the court said that the no trespassing sign that the officer saw on the front yard and the side yard did not protect Mr. Carlos. But what about the sign that was attached to the front door? That particular sign said, posted private property hunting, fishing, trapping, or trespassing for any purpose is strictly forbidden. Violators will be prosecuted. Now, the court says that this particular sign was a bit confusing because some of the activities listed normally do not occur within the home or even within the curtilage of Mr. Carlos's home. We're talking about the fishing and trapping and so on. None of that occurs on the curtilage of Mr. Carlos's home. Now, another thing that the court says is that when objectively reading this sign, some individuals, for example, a mail courier or pizza delivery person or a police officer, would still think that they have a right to come up to the front door. Now, of course, we can disagree with the court here. I can tell you in these examples, I will say that, for example, with mail courier, I think it will depend where's the mailbox. If it is attached to the front door or next to the front door, I would assume the mail courier can go through the front yard to get to the front door and deliver the mail. But if the mailbox is located in front of the house next to the street, I see no reason for the mail delivery person to walk up all the way to the front door. Now, with the court's second example of the pizza delivery person, well, again, when we order pizza, the individual is the one calling the pizza delivery person. Unlike in this case, Mr. Carlos never called the police for them to come up. And with the pizza delivery person, I would assume that when you call, if you don't want this individual coming up to the front door and knocking, you can give special instructions telling the pizza delivery person to either meet you in the front yard, or if you have, let's say, a baby and you don't want somebody knocking on the door, you can ask them to give you a call instead of knocking on the door, and so on. So, of course, you can revoke the license in these other examples. So, tell me, what do you think about this case? In the comments below, what do you think? Can the officers approach the front door if they see all of these no trespassing signs, especially the one on the front door? But I will tell you, here's the lesson that you should take from this case. Get yourself a fence around your property. Because if you have a fence around your property, even if it's a 2-3 foot fence, it will tell an individual, that the police, that the area surrounding your home is now called curtilage. It will be intimately connected to your home if it is somehow enclosed and close to your house. So that's the lesson you should be taking away from this case. If you enjoyed this video, please give it a thumbs up. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, stickers, and some other items. And finally, again, I'm a criminal defense attorney. I handle cases all over California and Nevada. If you have any questions, whether it is a federal or state case, I will be able to help you. Give me a call. Thanks for watching.